Good evening. This is Rahul Reddy live from Houston, Texas. Every Tuesday from 5 p.m. to 6 p.m., we bring in immigration updates, storm, hurricane, whatever it is. But just before we go into it, we are having a lot of technical problems. If by any chance we get cut off, please excuse us because Houston is facing a lot of electric issues, internet issues. So, Emily, what do we have today to discuss?
Yeah, today we want to talk about priority dates. What is it? Why is it important? What is the significance of it, especially for employment-based immigration? And the August 2024 visa bulletin is out. Not a whole lot of good news in it, a little bit of forward movement, but not much. What does that tell us about the future for those that already have a 485 pending? Going back still to October 2020, we still have a lot of people there. How much longer is it likely to take, and what are your options right now if your date is current? And then we want to talk about EB1, especially for India. It is backlogged 2 years, 2.5 years now, and it doesn't look to be getting any better. What do we see for that? We've got some updated data from USCIS. Their inventory numbers came out again last week. So we'll go through that. And then what are your options when your AOS is pending for a very long time? What are some of the challenges people face with that? Difficulties, what you should be aware of, how you can overcome those challenges and continue your process to finally receive the green card.
Emily, on the employment based, as everybody knows that when the labor certification has been filed, the priority date will be established, but until the I-140 is approved, it's not confirmed for the person. That's one way the priority date is established. That means that, let's say the perm labor certification has been filed in January of 2023. The I-140 must be approved for the priority date to be confirmed. This is from the perm labor. Most of the EB2 and EB3 fall into this particular criteria. Now, when it comes to the EB1 category, it is when the I-140 has been filed. Of course, it will be only confirmed when the I-140 is approved. And a lot of people get confused. Priority date is on the day the perm is being filed if we are using perm as the basis for filing the I-140 application. If you're filing a direct I-140, which people may surprise, what is direct I-140? Especially for EB1A, EB1B, and EB1C, all EB1 categories, we do not file perm labor, we directly file an I-140. So it's on the day the I-140 has been filed, but will be only confirmed to you if the I-140 is approved. If by any chance I-140 is not approved either in the perm or in the EB1 category, the priority date will not be confirmed to you. There are very little exceptions for it, but that's the general norm. Also, when it comes to the EB2 national interest waiver, where we don't need to file a perm labor certification, the priority date is established on the day the I-140 has been filed and will be confirmed when the I-140 has been approved. These are the general norms. There are some very rare exceptions that are available. Why is this priority date important is when you are going to get the green card, though, what they look into is whoever has applied before will be allowed to apply for the green card. For example, if you're international and if you're wanting to file the adjustment of status in EB1 criteria, then they look into, they will every month, the visa bulletin is published, the date, anybody before that date can file the 485 application. Anybody after that date cannot. On that date or after that date cannot file the 485 application. The same thing is true for EB2 and EB3. It's called final action date. In some cases, it is filing dates. It's the visa bulletin which the State Department publishes. So the earlier the priority date is established for you and confirmed to you, it is better for you because in that way you have a chance of getting the green card faster. Sometimes, for example, if the priority date was December 25th of 2014, and if the priority date was on January 1st of 2015, that makes a lot of difference. Sometimes it may even take one decade difference just because the priority date is just 1 day or 1 week before. That's how crucial it is. Now, I've seen time and time again, sometimes people miss out by a week or 10 days. That's very sad to them, but that is the unfortunate truth. Emily, can you explain more about, how the priority date is established? Is it when the labor is filed or labor is approved, or is it I-140 approved, Emily?
Yeah, so your actual priority date is going to be, if you're filing a labor certification, the day your labor certification is filed. And if there's no labor certification, then the day your I-140 is filed. So that establishes the actual date. It's the filing date of either your labor or your I-140. But that date does not actually become yours until your I-140 gets approved. So if your labor gets denied, you don't have a priority date, even though you know the date it was filed. If your I-140 ultimately gets denied, you do not have that priority date. You can't keep it for any future filing. So that's one thing to be aware of. And then the whole point of this is to basically determine where you're at in line, because we do have a limited number of green cards available every year in employment-based. They're divided by the 5 categories, and then they're divided by country of birth. And so to ensure, supposedly, that people receive the green card in the order of their priority date, that's why we set that, so that whoever was in line first gets their green card earlier than someone who got in line later. But because of country of birth and the 7% cap, it ends up being that people from other countries who got in line later received the green card much faster than people from other countries, mainly India and China. So it doesn't necessarily mean your place in line in the whole line. It's just your place in line for your particular country in your particular category. And we see the visa bulletin moving forward and backward and forward and backward. And so sometimes your date is current and you can file. Sometimes it goes backwards after you filed. Sometimes if you didn't file fast enough, you miss out. Or sometimes that date, you feel like it's moving every month, it's making forward progress, and then all of a sudden it doesn't move. And it takes forever, as Raul mentioned, like a decade for it to move, just 5 days for people to actually be able to file again. That's kind of what we're seeing in that 2014, 2015 range for EB2, EB3 India. So a lot of times though, we have people who have priority dates that span different years, and some people with later priority dates that happen to be current end up receiving the green card before people who filed before them on the 485. So the 485 is also supposed to be first in, first out, and based on priority date. We've seen very clearly that that's not how they process these applications. So it's really just when your date becomes current, you want to get that 485 filed and make sure it gets adjudicated as soon as you can by including your medical exam, making sure you have all of the necessary documents, and sometimes litigating if needed to be able to get that approval before green cards run out for that fiscal year.
Well, let's move on to the topic of the visa bulletin. We haven't seen much improvements. We're going to cover second and third topic together. We haven't seen much improvements in EB2 and EB3. There was a 1 month advance in both filing dates and final action dates in EB2. That was expected from before, but what about EB1? What's the problem with EB1? What do you expect going forward the problem will be in EB1, Emily?
Yeah, EB1, mainly because of the big delays in EB2 and EB3, more and more people are filing in EB1, which is now causing EB1 for India to have that cutoff date when, for the past several years, at least during COVID times and post-COVID, EB1 was readily available. The problem is, as more and more people are filing in EB1, now we have this backlog. And looking at the statistics, so we just got the 485 inventory report last week. It goes back to the actual data is from May 2024. So it's a little bit outdated, but not much. But the scary thing is USCIS already has pending 485s for people, 10,000 people after February 2022, which is where the current cutoff date is. So they've already received all the 485s for people before February 2022 cutoff date. On top of that, the date had been beyond that before. And so some people were able to file, and then the date moved backwards. So we still have 10,000 people to get through who've already filed a 485 in EB1 for India. How long does it take to get through 10,000 green cards? Well, with the 7% cap and whatever we get left over from the rest of the world, which they don't use, pre-COVID, that was 9,000 green cards total for the year. There's 10,000 people already pending. So that tells me, based on this data, for people who've already filed the 485 in EB1, it's going to take at least a year just to get through that current pipeline. On top of that, we know how many EB1 I-140 approvals are out there that do not have a visa available. The date is not current. It's a little more outdated. This is going back to March 2024, but that was another 15,000. So if they're only able to issue 9,000 a year, which could be even less going forward as more rest of the world people are filing in EB1, it could take 3 years to get through just what's already in the pipeline, the 485s that are already pending and the I-140s that are already approved. That does not count people who are able to jump into EB1 and retain an older priority date, who basically jump in line ahead of all the people that are already in line in EB1. So I think we're at a point, if we're talking 3 years to move beyond, the current, to get to current, that's going to be 2027 before the date moves to 2024. And more people are continuing to file in EB1 because EB2 and EB3 are backlogged. We could get to a situation where people max out of L1A time for those that are filing in the EB1C category. So you really need to think about how far off your date is from becoming current, how much L1A time you have left. Even if you have 7 years, if you didn't start your green card process until your 5th year, you may very well run out of time if we're talking about at least 3 years just to get to 2024 if you're filing now. So that's something where people with L1A might need to consider switching over to H1B, because L1A, even if you have an approved I-140, you cannot extend beyond that 7-year limit. With an H1B, you can extend beyond the 6-year limit. But if you're going to convert from L1A to H1B, number one, you've got to make it through the lottery. So you've got to get your name put in that year after year, most likely. And number two, you have to do it before you actually hit 6 years of L1A time, because the time you spent in L counts towards your H1B 6-year limit. So there's a lot of moving parts with that. Other options are to take some strategic trips outside the US to be able to recapture that time until your green card final action date becomes current, or your filing date becomes current, so you can file that 485. What do you think about these EB1 dates? I mean, are we, have we seen this before where EB1 India was this backlogged?
No, not really. Even though we have seen some delays in 2020, where we have seen backlog about 2 to 2.5 years ago, I believe that the EB1 backlog is going to increase significantly. The main reason is that the rest of the world, as everybody knows, that 40,000 green cards are being allocated for the EB1 category. And out of those 40,000, Indians can get 2,800, because 7% will be 2,800. In those 2,800, Emily, typically there are family members, spouse, children who are born outside the country. So it's only approximately around 1,200 to about 1,400 families get the green card every year, Indian nationals. That's for assured that Indian nationals are going to get up to 1,200 to 1,400 families that get the green card every year. Now, the rest of them, as you said, that previously Indians were getting almost 10,000 or 9,000 green cards every year, was previously the rest of the world was not using up the green cards under EB1 category. Since the rest of the world is using more right now, there are multiple reasons which I will explain. The Indians are only constricted very less number of green card in the EB1 category. So if Satya Nadella kind of people are talented, very top CEO kind of people, or Sundar Pichai kind of people apply, they're in a very good role. They should get an EB1 I-140 approval. Definitely, they will get an EB1 I-140 approval. They still have to wait multiple years to file the adjustment of status. So that is going to be there for Indian nationals because the 40,000 limit plus 7% per country limit and rest of the world, this is the most dangerous thing. The rest of the world are using more. Also, Emily, I have noticed as, I've been practicing immigration law for such a long period of time. I don't want to discuss it. My age will be disclosed, but such a long period of time, it has never been easier to get an EB1 approval as compared to what it is today. Never been easier. Now, I don't know what's going to happen later on if the administration changes, but it has never been easier. Now, it's a blessing and a disguise for some people. So it's a blessing for those people who are getting approved, for the disguise for those people who are waiting in the line. So that is also a major problem for EB1 category. I've also noticed that a significant amount of people are trying to move from EB2 to EB3. These are the people where I call as cutting the lines. If people are standing in the line, these people are right going in between. Now, I know that's not allowed in USA. That's not people don't do in USA now, but that's allowed when people do it from EB2 category to EB3, from EB2 or EB3 category going to EB1 is very likely right now. People either are trying to qualify for EB1A category or they're trying to go outside the country, work for 1 year and come back and get the green card through EB1C category. Now, a lot of people need to understand that you can port the date from EB2 or EB3 to EB1 category. You can port the date. And that's an advantage for a lot of people who are waiting in line in EB2 and EB3. At the same time, it's a disadvantage to the people who already got an EB1 approval because these people are cutting the lines. So definitely EB1 is going to be a major problem. The same problem what we have noticed for EB2 and EB3, that the priority dates don't move that far and they're almost blocked at 2012, could happen, or I would say will happen, not to the same extent as EB2 and EB3, but to some extent, I would say that I may expect a backlog about 5 to 7 years, Emily, going forward in EB1 category. That's my expectation for EB1 category. Anything else?
All right, last topic. With these visa bulletin dates not moving or moving forward very slowly, a lot of people end up having a 485 pending for years, even a decade, before the final action date becomes current and they're able to get the approval. So what are some of the challenges people face when their 485 has been pending for a very long time?
If the 485 has been pending for a long time, Emily, people need to, it's very frustrating and people go crazy. Why is that I'm waiting for this prolonged period of time? I just want one simple suggestion for them. Hey, buddy, it's much better than being an H-1B. It's much better than being an L-1, definitely, because it's easier to extend the EAD. It's easier to extend the advance parole. Now, there are some catch points of advance parole I'll discuss later on, but it's so easy when you apply for EAD extension, at least for the people who filed the adjustment of status applications before April 1st of 2024, which most of the Indian nationals are. And since your priority date might have been backlogged, you're not going to get the green card. They may call you for the 485 interview, but they can't give you the green card. So it's going to be there. Be prepared to sit there for a long period of time. And Emily, now recently, the USCIS has released the data with regards to how many number of applications are pending in the EB2 category. Now, I see that in some of the months, Emily, like for example, in October of 2014, there are 2,252 people are pending for the adjustment of status. Where priority date is current, it was October 2014 people. Right now, 2,252 people are pending in these categories. So the entire EB2 and EB3 combined is only about 2,800. I'm not good in mathematics, but it's 5,600 people are allowed every year for Indian nationals to get it in EB2 and EB3 category. So if I look into the data, though, it may take a long time for January 1st, 2015 to clear. I mean, especially for those people who filed in 2014, it's going to take a long time. And priority date is 2014, I'm sorry. It might take a long time, maybe up to 5 to 7 years, even long period of time. So I want you to guys to relax, stay on the EAD. If it's up to you if you want to maintain the H-1B, it's up to you if you want to get rid of your H-1B. Now, what are the catch points if they get rid of the H-1B? What are the advantages or disadvantages? One thing is that if they get rid of the H-1B, it's easier to extend the EAD. Believe me, guys, it's so easier to extend the H-1B. I don't want to even tell our fees for how much we charge for the EAD. It's so low. I don't want to even tell it in there. It becomes I become a cheap guy in filing the EAD extension. It's so cheap that when we file for the EAD extension, and there is no filing fees for the EAD extensions. So and now you're getting 5 years of EAD extensions when you file the EAD. 5 years. They don't ask the end client letter. They don't ask the vendor letter. They don't ask the employer letter. They don't ask you to file a very long I-129 form nothing at all. I mean, just file the I-765. It's a very simple form. Say that your 485 is pending and give the pictures to them. That's it. It gets approved. Nothing much. And it gets approved 3 to 4 months, and sometimes it may take up to 4 to 5 months. And the good part is that even if you file an EAD extension, Emily, let's say my EAD is expiring in August 1st of 2024. If I file the EAD extension right now and I don't get the approval by August 1st of 2024, I can work up to 540 days, even though my EAD is still pending, which is taking only 4 to 5 months for them to adjudicate. That's the advantage. Now, the catch point is, which we see most of the difficult part, is the travel part of it. Now, I said EADs, they can work for 540 days. The same rule is not there for advanced parole, which is required for them to travel outside the country. That becomes a problem. Now, of course, Stephen Brown in our office has a solution. They can go to the court and get it resolved in 70 days approximately. That's a better option if you want to choose the leave the H-1B and go, and you want to travel. Probably going the court litigation is a better option. And you are getting the 5-year extension. Once you get it, you're set for 5 years. So, which is a good part. So, normally I see a lot of people moving on to the adjustment of status EADs rather than maintaining the H-1B nowadays.
So, if they're giving these EADs and APs for 5 years, does that mean I can go outside the country and wait for 5 years until it's time to come back and file another one?
No, Emily. The reason is that the reason why you are getting the green card in United States is because you said on your 482 application, you have a job here in United States and you're going to stay in United States. You want to stay permanently in United States. When you signed the I-485 application, that's what you said. So when you're living there for a long period of time outside the country, you're showing your intention that you don't have a job, you don't want to stay in the country, you don't want to immigrate into the United States. So that is definitely no. If anybody has any travel plans to go more than 3 or 4 months outside the country and stay outside the country and advance parole, please check with your lawyer what are the negative implications before you embark onto the journey.
All right, I think we can move to questions. Srinivas says, when can we expect a second H-1B lottery? Based on what we're seeing, USCIS is still in the receipt process for the first lottery. A lot of people filed in the last week of June, and we have not received receipt notices for all of those yet. They're still cashing filing fee checks. So they don't even know how many have actually been filed yet. When we had a second lottery before, I believe in mid-August is when we started seeing those selection notices. There was no announcement beforehand. We just started seeing selection notices. And then a few days later, they came out and said, oh, by the way, we did a second lottery. It's over now. I don't think there's going to be one this year, but if there is, it would maybe be mid-August.
Akshay Agarwal has this question. How does this cross-country chargeability work? I'm applying for NIW, National Interest Waiver, which is under EB2 category. Akshay, cross-country chargeability, for a lot of people, I will explain it, what that is let's say you are from India, you're born in India, you are brought up in India, your passport is in India. However, let's say you married somebody who is born in United Arab Emirates. Okay, let's say Dubai, the city that normally people say. Now, even though that person, that lady, may not be a Emirati citizen, she still holds the Indian citizenship, even if she is born in United Arab Emirates. You can use the country of birth of your wife to file the 485 application. So in your case, Akshay, let's assume that you are from India and your wife is born in UAE and she's born in Dubai, but she still has an Indian passport. Then you will be considered not an Indian under the cross-country chargeability, and you can file the priority. You can file the 485 based on other countries though, not Indian, because your wife is born in Dubai. Now, people may ask the question, well, it's not Akshay who's born in Dubai, it's his wife who's born in Dubai. I know that. That's the reason why we call it as cross-country chargeability. Using the country of birth of your wife. That's the reason we are using it. And people ask the question, she is not a UAE citizen. Though she is born in Dubai in Emirates, she is not a UAE citizen. How can you do the cross-country chargeability? Country of birth will determine the immigrant status. For the immigration purposes, country of birth is the important thing. Since this is just an assumption, please actually don't call me and say your wife is not from Dubai. But let's assume that. So if the wife is from Dubai, she's born in Dubai, even though she doesn't hold the citizenship, we can claim the cross-country chargeability. And it's not a big deal at all. Believe me, it's not. We don't even charge anything extra for it. And you get the I-140, you can either get the I-140 approval, come to us, we can file the 485 application. We charge the normal fees, nothing extra for that. Then we don't do any extra work. We just put a sheet saying, hey, his wife is born in Dubai. Here is the Dubai birth certificate or United Arab Emirates, and we mention the section number, the cross-country chargeability, and that's it. They just accept it and they give the green cards. But the point is that both you and your wife have to file the 485 together. Not that she is in India and you're here, you're filing 485 alone, saying that your wife is born in Dubai. That's not enough. Both have to file the 485 together. Now, when you file the I-140, of course, you're just filing a loan I-140, that's fine. You can file the I-140 alone. But when it comes to the I-485, both have to file together.
Pakala Prasad says, I will be current in August 2024 and EB3. I filed back in October 2020. Medicals have expired. What can or should I do now to proactively move the case? No RFE for medicals yet. So this kind of takes us back to the summer of 2022 when we were determined to make sure that USCIS did not waste a bunch of green cards again like they did in the prior year. So we wanted to make sure everybody was ready to go, had everything submitted so that USCIS could approve them all by September 30th. So for the medical exams, even though USCIS will tell you, please don't send us unsolicited evidence. Based on our experience, we recommend getting the medicals done, get 2 originals, 1 to send in now, keep a second one with you, send it in doing what we call an interfile request. Very simple, just cover sheet explaining what you're submitting. We have explanation on our website. Go to rnlawgroup.com and search for interfile, and you'll find instructions for that. But you basically mail in your medical exams and ask them to put it in the file. So when they open up your file, they're already there, and they don't have to send you an RFE asking for it. Now, why did I say get a second batch of the medical exam? Because sometimes that interfiling does not actually make it into your file. You have to make sure you're sending it to the service center where your case is actually currently pending. And then sometimes just it gets lost in the mailroom or it never makes it into the file. So in some cases, you may still get an RFE asking for the medicals, even though you've sent them in. That's fine. You already have them with you. You can turn around next day and mail them back to USCIS to get the approval. So we do recommend that. And then for the service center where your 485 is pending, check the current processing time. If it's showing that it's outside normal processing time, you may actually be able to submit a service request. I was able to do that for a case just today, where the normal processing time is listed as 30 months and the case has been pending for over 36 months. Even though the date just became current, I was able to do a service request because the online case status still says that case remains pending because an immigrant visa number is not available. Well, based on the visa bulletin, it is available. So I'm going to try to get their attention to get them to move forward on that case. So those are two of the things that you can do. And then consider litigation. Now is the time to do it if you're going to do it, because you want to make sure that the approval can be issued by September 30th before this year's green cards run out. We had a lot of people in 2022 September where they ran out of green cards early, September 6th, if I recall, and a lot of people were left with nothing, without the green card in that situation. So if you're going to consider litigation, now is the time to file it. Contact Stephen Brown in our office to understand what that entails, but do it now so that you can get your green card before September 30th.
Question from Krishna Reddy Velagala has this question. Am I eligible for national interest waiver? Means this is for EB2, where people can file the I-140 application directly, and they don't need an employer to file that. They can file it by themselves. He works in artificial intelligence. He claims that it's not that all fancy, but just to start stuff. Not sure if I'm eligible for it. Well, you're telling, definitely if you're just working for artificial intelligence on the topic, you may or may not be eligible. But what is not fancy for you, what is just starter stuff for you, is maybe for us it's a miracle. I mean, believe me, artificial intelligence for us is miracle. The things that artificial intelligence is doing is miracle for us. I mean, that's what the administration also is thinking, to promote the artificial intelligence. And we're also seeing that when we file the EB1A cases or national interest waiver, in the artificial intelligence, the approval percentage is way higher than the normal other, let's say, for example, in civil engineering stuff or mechanical engineering stuff as compared to artificial intelligence. We do see that. So it may be worth for you to get it evaluated. And a perfect person in our office will be Kareem Zivani from our office. Make sure you just go through one of the YouTube we did on national interest waiver and try to highlight the points that you may have in the artificial intelligence, and then have a consultation to have him evaluate to see. Now, sometimes you may not. Sometimes the lawyers may advise you're not eligible for it. You may not be eligible for it, but they may give a guidance. What are the steps that you can take to get the eligibility? Maybe you can do some steps. Maybe you can be a speaker on some conference, or you can publish some articles. Maybe you had patent some of those things. What you do, there are many different things that what you can do. Maybe you will be eligible at a later date after 6 months for the NIW. You can try it. I also recommend a lot of people who work in artificial intelligence to also consider EB1A application too. We do have consultations. Not all the people who have consultations go through as an EB1A application, get the things approved, but there are a good number of them that get approved, get hired and go through the process. There are a good number of people. Kareem advises them, what is in the next 1 year, next 2 years, next 3 years, what is the plan to get it approved under the EB1A or national interest waiver? You can get the advice on that too.
Sharon says, I was laid off on H-1B and applied for an H-4 and H-4 EAD together. They're still pending. Can I move back to H-1B when I get a new job and then later come back to H-4 and H-4 EAD when those get approved? Yes and yes, you are able to still file a change of status back to H-1B while your H-4 and H-4 EAD are still pending. not a problem at all. We recommend filing the H-1B and premium processing because you cannot start working until it gets approved. And then later, assuming your H-4 change of status and H-4 EAD do get approved, you can convert yourself to H-4 and continue working on EAD and then switch back to H-1B. You can go back and forth doing what we call the margarita switch, taking a quick trip to Canada or Mexico, and coming back and showing the I-797 approval notice with the I-94 with whichever status you want to be entering the U.S. in, and that will be your new status going forward.
RC has this question. His priority date is April 2015, which we know might take a long time under EB2 category or EB3 category for him to file the adjustment of status. His question is, can he move to H4 EAD, and when it becomes current, can he move back to H1B and file the 485 application? Now, I'm assuming that you're working with the same company on H4 EAD. The crucial point here is that the company that got the I-140 approval should be willing to file the 485. That is important. Now, can you come back to H1B after moving to H4 and then file the 485? The answer is clearly yes, you can. Do you need to come back to the H1B to file the 485? Absolutely not needed. On H4 EAD, your company can still file the 485 application even though you're not on H1B. Even though you're on H4 EAD, you can still file the 485 application. Even though your wife is on H1B and you are on H4, you can be the primary applicant in the adjustment of status, and your wife can be the dependent on the 485 application.
Banu says, my H4 and I-94 are valid until 2026, but my current H4 EAD expired in June 2024. My H4 EAD renewal is in process. Can I continue my current job and continue my payroll? Assuming that your I-765 for the H4 EAD renewal was filed before June 2024, when your H4 EAD expired, yes, you're eligible for the automatic 540-day extension of your EAD because your H4 has already been extended till 2026. So you can keep working based on that and continue to be paid as normal. If your H4 EAD renewal was filed after your current EAD expired, then you do not qualify and you have to stop working. You're not eligible.
People are asking questions with regards to when do we see the priority date, when do we see the labor certification approval? We are looking in, I'm just opening the things right now. We're looking in somewhere in June of 2020, May and June of 2023, May 2023, sorry. I haven't seen any June yet though. So it's in May of 2023. Let me take it back. May of 2023 is what I've seen. I've seen until May 31st of 2023. I haven't seen anything in June of 2023.
David says, AOS was filed, wife is on a TD and will expire soon, visa bulletin retrogressed, so AOS cannot be filed. TD status is expiring soon, what can we do? So if I understand it right, AOS has only been filed for the main applicant, but not for the spouse. TD can only be extended if the TN is extended. So having the pending 485 may make it difficult for the TN to be extended, which means the TD may not be able to be extended. There's not a lot of good options there, other than trying to extend the TN and hope it works out and extend the
Emily,
TN.
how about student visa though for her? She didn't file.
I was just going to say convert her to another type of visa. F1 could be an option. A TN, if she's Canadian as well, she may be eligible for her own TN. Anything that's not a dependent on the main applicant would be necessary for that. Otherwise, it would be consular processing for her, and she waits outside the U.S. until she receives her green card.
Kelby 26 has this question. can I apply H4 in my home country, not India? And this person's spouse is from India. Let's say, for example, this person is from Cambodia, and the spouse, the main spouse who's in H1B is India. Can you apply in your country? Absolutely. Not a problem, never a problem. You can apply H4 in your home country, even though your spouse is not from that particular country, you can. Vani has this
Yo
question.
Money says, my dependent's AP has not been approved for the last 22 months with the Texas Service Center. I got mine fairly quickly. My lawyer is asking us to wait patiently. Do we have any other options? Well, you've been far too patient already at this point. Do not keep waiting. Contact Stephen Brown, file a lawsuit, get the AP approved. That is ridiculous.
And if we keep filing more lawsuits, though, there's a possibility they may bring the time down. And they did make some changes when they started suing on these things, especially they made 5 years EAD approval, 5-year advance parole. So there are some indirect benefits. May not be for the same person who filed it, but for the people who are in the line, definitely there are some benefits in there.
Usha says, my priority date became current with my previous employer, but that company closed in 2020. My current employer filed for the perm in April of this year. Do I have any options? Look at the NIW. You can skip the perm. Look at Schedule A. What is it? Exceptional ability? I can't even remember. Extraordinary ability, exceptional ability, the new Schedule A. But NIW, you can directly file an I-140 if you qualify. And if your date's current, you can file the 485 along with it. You don't have to necessarily wait out the perm. But if NIW or EB1A is not an option, then yeah, you've got to wait for the perm to be approved, unfortunately.
Wait a minute, Emily. The priority date was current in 2020, September. We got the dates. This lady hasn't been acting on it for like 4 years?
A lot of companies drag their feet to file the perm.
Okay, can I file a labor certification with the company I'm not working, Emily? Is that an option too?
Yep. Yeah.
I think so. Yeah, especially 4 years wait time is a long period for me. Okay. Vani has this question. What happens if the kid who is 17 years uses a GCEAD for working as an intern and the parents remain on H1B and H4? The kid becomes married, what we call, to the adjustment of status, and the parents are still maintaining the H1B. They can maintain the H1B, and the kid can get married to the adjustment of status. Absolutely not a problem.
SS says, I'm currently in the recruitment phase of the green card process, and the company set a salary range that is greater than the current base pay. The attorney said this is a forward-looking process, but I don't understand any suggestions. Well, number one, the company has to meet the prevailing wage. So it's possible that your current salary is below the prevailing wage for the perm process, because it's a different process. The DOL tells us what the prevailing wage has to be for the perm process. So they have to offer a higher salary, regardless of what your current salary is. And they're correct. It's a forward-looking process. That means the salary the company is offering on the perm is not the salary that they have to pay you today. It's the salary that they have to pay you when you get your green card, however far in the future that is. So it has nothing to do with your current pay. The only way that your current pay becomes relevant is to show at the I-140 stage that your company has the ability to pay that wage offered. So having the current salary that's lower than the offered wage for the perm can create a problem for your I-140 if the company's financials are not strong enough. But otherwise, there's no issue with that at all.
Rakesh has this question. This question comes to me very frequently. People say that I do have a master's degree. I do have a 20 years experience. Am I qualified for NIW? Experience automatically doesn't qualify for NIW, and experience does not automatically qualify for EB1A. Absolutely, that is not even one of the considerations. For example, in EB1A, there are 10 categories. Experience is not one of the categories. It is not listed. If somebody has 50 years experience, can they get one out of the 10 requirements? No. Sometimes I believe experience only tells your age, it doesn't tell your achievements. So for NIW or EB1A, I want you to tell what are the achievements? Why are you in the national interest? Why are you in the national interest for the United States? The work that you're doing, how is it benefiting? Is it directly benefiting the work that you're doing? Let's say you're part of the team, and that particular team is developing a security product which is going to protect from outside. Let's say North Korean people trying to strike or Iranian people trying to strike us in financials and the other things. You may be eligible for national interest waiver. But if you're just saying, I do have 20 years experience, the first thing they throw it out, they'll deny it because that's not one of the considerations. You may want to thoroughly go into the video we made on the national interest waiver and look into what are the qualifications required and then have a consultation with Karim Jivani. But experience by itself is not enough.
AJ says the H-1B got an RFE asking how the LCA corresponds to the position. The attorney's not sharing the details, but he wants to know, has the company or the attorney made a mistake that caused this RFE, or are these things easy to get approved? It's not necessarily a mistake. There are a couple of ways that this question comes up. The first one is maybe USCIS thinks a different SOC code applies to the position compared to the one selected by the attorney or the company when the LCA was submitted. That can just be a difference of opinion if the attorney can explain how the code that they selected is more appropriate than the one USCIS thinks it should be. Should not be a problem at all, as long as that SOC code is for a position that requires at least a bachelor's degree in a specific field of study. That one's not difficult to get approved. But if they selected a completely inappropriate SOC code, then you've got a problem if it has nothing to do with the job. Maybe that was a mistake. The other main issue that comes up is, did they select the correct wage level for that position? If they selected a level 1 wage, which is for an entry-level position, but in their employer letter, they're saying that this job requires 10 years of experience and the person has to be an expert in Java and SAP and I don't know what else, anything else related to IT, that is not something that can be easily overcome because they've gone on record saying it's a higher level position, but the LCA is for an entry-level position. So those are the types of issues. Could be just a difference of opinion, and they need to be able to explain why it is they selected what they did on the LCA and how it still qualifies.
SS has this question. He's in cybersecurity professional, got an MS degree and has an I-140 approval. Any chance for NIW? Yeah, you can definitely, because you work in the cybersecurity. If you are in the national interest and your tasks that you're doing are in the national interest, you can be eligible for national interest waiver. But SS, that doesn't give you a lot of advantage. It definitely gives independence from your company, but EB2, NIW is still EB2, it's not EB1. You may want to look into consideration of EB1 though, because EB2's priority date is all the way to 2012 right now. So you're not going to get the green card right now, assuming your priority date is somewhere in 2015 or 2016. So you may want to consider EB1A application more than NIW though.
VSN says, I applied for my perm in December 2023. When can I expect to get it approved? I would say January 2025 would be the earliest, unless we see a drastic improvement in processing times. And it may be longer than that because we're just about to get into the flag approvals, which we don't know how DOL is interpreting some of the questions on how they've changed that form. So there might be some delays in getting approvals as we switch over to that new system.
Vivek has this question, and this question comes very frequently to us. And this is when people are in adjustment of status, when they lose the job, what do they need to do? Everybody knows that if people are on H1B, if they lose the job, they can get a job within 60 days, or they can move on to B2 and move back to H1B at a later date. As Emily has described previously, that is an easy option that is there. But when it comes to the adjustment of status, here is the question: which one you want to save? If there is no 60 days rule of unemployment on the adjustment of status. At the same time, in the adjustment of status EAD, there are a lot of flexibilities. You can get a self-employment. Your wife can employ you. You can join some company without H-1B. So normally people come to consultation. First thing that I would like to save is the adjustment of status. Now I can always get this guy H-1B back at a later date. They can go to India and get the stamping and come back. That is there. But the first thing that I want to save is the adjustment of status. That's what I want to save. The second priority mine will be H1B. Sometimes because companies, when you want to join, they don't want to file the H1B. They don't want to go through all the process. Come join us on the EAD. I tell them go join on the EAD. If that's not possible, can you self-employ yourself? Because self-employment H1B is very unlikely for you to get the H1B approval under the current conditions. So I tell people to self-employ themselves on the adjustment of status EAD. So you have to have the priority. Which one is the priority? Adjustment of status or H1B? Definitely, if the H1 is the only priority and you want to kick your adjustment of status in the trash, don't come to me because I'm not the proper advisor for it. If you want to keep the adjustment of status and you want to continue on the adjustment of status, I may be a very good person for you to come and join. And for that, self-employment is one thing. Your wife employment, getting a job offer from some other company is important for you.
Rakesh says, my wife is a BSN RN and currently working in a university hospital in New Jersey. Can she get an H-1B because she has an EAD through me as my dependent? My daughter's actually a BSN RN and going to start her first job at a hospital in about 3 weeks here. So, but anyhow, that didn't answer your question. So there are two issues. Number one, is the hospital cap exempt? It sounds like they might be because you mentioned it's a university hospital. So teaching hospitals typically are considered cap exempt and can file H-1B any time of year. No need to go through the lottery. The other issue is not all RNs are eligible for an H-1B because the H-1B requires that the job has to normally require at least a bachelor's degree in a specific field of study to enter that occupation. But not all RNs need a BSN, bachelor's degree. Some states allow associate's degree to still get an RN license. So if that's the situation, then you have to look at, does her particular employer require only a BSN for that particular job? And they don't accept people that have an associate's degree for that role. If that's the case, and they can document that they only hire those with a bachelor's degree because it's a more complex role or whatever the case might be, then it is possible.
I mean, what about these the nursing practitioners? Are they?
Yeah, they should definitely qualify for H-1B because that is basically a doctorate in this day and age.
Question that comes is that my advance parole extension is pending. I'm assuming the current advance parole is still valid. And can he travel outside the country in the advance? Can you travel? Assuming that your current advance parole, let's say, for example, your advance parole is expiring in September of 2024, and you filed the advance parole extension right now, and the extension is pending, and you are leaving the country and returning back before the advance parole expires, which is September of 2024, I don't see any problem whatsoever at all in your traveling. The extensions don't get denied. It's only the initial advance parole applications, the first advance parole application, if you leave the country, they're denied, but the extensions don't get denied.
AMGC 1978 wants to know how litigation works when there's already an attorney handling the paperwork. Maybe the employer has their immigration attorney and you've worked through that attorney all through your whole process. And it's totally fine. That attorney does not need to be involved at all. That you can continue to have that attorney as your attorney for your paperwork, for your process. The only thing that the litigation attorney does is file the lawsuit. So everything else can still remain with your employer's attorney. You don't need to tell them that you're filing it. It doesn't matter at all. So you can still do that even though you're already working with an immigration attorney. Banu says, my husband recently moved to a new employer, got his H-1B approval. That's good till 2026, but his passport expires in 2025. Can he just renew his passport next year in 2025 and stay in the US? Or does he fall out of status because his passport expires before his I-94? As long as he's not traveling, no issues at all. He can stay in the US. He's still in H-1B status. Just make sure to renew the passport before it expires, not after it expires. Where the passport expiration is a problem is if you are traveling and you come back before you've renewed your passport, then you're going to get a shortened I-94 that's only valid till the passport expiration, not the I-797 expiration. And if you don't realize it in time, it can put you out of status and make you unlawfully present, which is a big problem. But if you're staying in the US and you apply for the renewal on time, no issues at all.
Question from Bhumika. If I sign a mortgage as a co-signer and by any chance it goes to foreclosure, that means that she defaulted on the loan and the bank goes to the foreclosure, will this affect the GC in future? No, I don't see any problem at all. That this is going to affect, especially if you are filing the employment-based green card, assuming that your and your family income is more than $60,000 per year. I do not expect any problem for you at all. Okay. Chandrakant has this question. His priority date is July 2013, EB3 to India. When do you think so? Can we expect the priority date to be current by October of 2024? Very unlikely. We just got the result of 2020. We just got the priority date for August of 2024. So you have only 1 month, and 2013 is very unlikely to become current under the EB3 category. Very unlikely.
Vanny says H-1B bundle premium processed. So I'm assuming he means the H-1, H-4, and H-4 EAD were all filed together in premium processing, but the H-4 EAD is still pending, and the attorney says not to worry about it. Aren't they supposed to be approved at the same time as per the settlement? Yes, absolutely. If they're filed together in premium processing, they should be approved together. The attorney or the company should reach out to the premium processing unit and remind them of the requirement from that settlement agreement, and they should be able to get the EAD approved relatively quickly. But they do have to reach out. Well, I think we're out of time for today. Thank you everyone for joining us. As usual, we'll be back next Tuesday at 5 o'clock Central Time with more updates on everything related to employment-based immigration and answering your questions. In the meantime, you can always join one of our daily conference calls on Zoom. You can get the details of that by going to rnlawgroup.com and ask your questions live there. And don't forget, you can always book a consultation with us or any of our attorneys by going to rnlawgroup.com.
Thank you very much.